Well, good evening everybody. Welcome to this inaugural lecture. I'm Hazel Genn, Dean of the Faculty of Laws, and it is a real delight for me to introduce Professor Jonathan Montgomery, who is our new, just to be inaugurated, Professor of Healthcare Law. The creation of a chair in healthcare law in the faculty was a strategic objective of the faculty. We didn't have somebody specialising in that area, which is odd if you think about it in an institution which is about 60% dominated by medicine. And we saw this as a great opportunity to create a centre of excellence in healthcare law in the faculty and to be able to work more collaboratively with our medical colleagues. So it is a particular pleasure for me to be present at this inaugural lecture this evening. My principal job, apart from declaring Jonathan duly inaugurated, assuming he does give his lecture, is to welcome our chairman this evening. I am absolutely delighted to welcome Lord Toulson, who is a Justice of the United Kingdom Supreme Court. He is a great friend of the faculty, a very wonderful supporter of the activities of our law faculty. He is a most distinguished lawyer. He needs very little introduction here, but it is probably worth saying that he was previously a chair of the Law Commission. He was one of the people who gave judgment on the Nicklinson case when it was in the divisional court. He takes a great interest on cases on healthcare law, and he also recently published a book on confidentiality as an authority on confidentiality. So he is a most appropriate person to chair this lecture this evening, and what I shall do now is to hand over to him to introduce Jonathan Montgomery. Thanks very much, Roger.
Thank you, Hazel, and it's a great pleasure to be here. Even to summarise Professor Jonathan Montgomery's CV as an academic in the field of healthcare law would take longer than would be appropriate for a brief introduction. For over a decade before coming to UCL, he was Professor of Healthcare Law at the University of Southampton. He is the author, co-author, and editor of many publications in this area, including the leading textbook, Healthcare Law, first published in 1997. Academically, his position is one of preeminence. But his interest in and knowledge of the subject is not limited to the professor's chair. Indeed, when you look at his other responsibilities, it is a wonder how he ever finds time to sit down in his professorial chair. Until he left Southampton, he served for several years as chair of the Hampshire Primary Healthcare Trust. Until 2012, he chaired the Human Genetics Commission. He now chairs the Health Research Authority, the Nuffield Council on Bioethics, and the Advisory Committee on Clinical Excellence Awards. Besides those and other official posts, if there were enough, he's also involved in voluntary work with childhood incest survivors and with youth charities. His work has been influential in shaping the way in which academics see legal aspects of healthcare. And there is some evidence that this has had an effect on judicial thinking. There's generally a lead time between fresh academic thinking and fresh judicial thinking. It does take judges time to absorb and catch up, but there is no doubt about the potential influence of the one on the other. In this respect, UCL plays an unrivaled part in trying to connect the academic and judicial worlds. I have had the privilege of a sneak preview of Professor Montgomery's lecture this evening. It's very apparent that he is still thinking fresh. I promise you that the next 40 minutes or so are going to be thoroughly fascinating. And as you prepare to take off into new legal thinking, please, of course, make sure all mobile devices switch on. It is a real honour for me now to invite Professor Montgomery to let you into this thinking on the provoking subject, Patient no longer. What next in healthcare law?
Thank you very much indeed for those generous words, despite you having seen the text. And thank you all very much for coming, especially those for whom this is the second go around this. There's a number of friends and colleagues who nearly 10 years ago sat through an Inaugural in Southampton, including Michael Freeman, who travelled all the way down from here for it, much to my surprise and pleasure. I'm sure that many of you will notice some influences of yourselves, at least in discussions, even if you don't think you won the argument, in some of the things I'm going to say. And I apologise for not being explicit in the oral text about some of those things. The starting point is a question around the focus of discussions in healthcare law. And for a very long time, we've assumed that that focus would be with the doctor-patient relationship. And even when I tried to redefine the subject not as medical law but as healthcare law, it still seemed to me that the central question was around the position of the patient and what patients were entitled to and how they related to the health system. I'm just beginning to wonder, though, whether that's a satisfactory model. And when I first started working in the area, I thought very hard about what you could learn from the sociology of the professions about how judges seem to be thinking about doctors. And a bit of the context of this talk is thinking about what we can learn about the sociology of being a patient. And this is a particularly interesting time to be asking that question. I'm reflecting this evening essentially on 5 recent decisions, all of which have happened or are happening since I arrived at UCL, and that will be a year next week. So it's a peculiarly interesting time. So the Aintree and James case, Supreme Court decision, all about whether or not it was appropriate to withdraw treatment and what you should do in the case where a patient couldn't consent for himself. The Nicholson decision, about which I won't say a lot this evening, partly because I've already written a bit about it and partly because if only we'd stopped at the divisional court, it would have been a bit less of a mess, is part of the scene setting for this and has thrown down the gauntlet for the legislature as what it's going to do in the case of people, not patients here, but people who wish to be helped on their ways to death. Thirdly, I want to talk about a case not yet decided, which I wouldn't have picked up were it not for some research work by my daughter, who's in the audience and is aptly named Montgomery, although no relation. This is an opportunity for the Supreme Court, and it's heard the arguments and it's about to pronounce at some undetermined phase in the future about informed consent, and gives us a chance to ask ourselves where the modern law takes us in relation to that area. The Dugan case is about 2 midwives from Glasgow who seek to rely on their rights to conscientious objection under the Abortion Act of 1967 to say that they shouldn't be required to manage labour ward. Much to, I think, many people's surprise, they won, and that's about to be heard in front of the Supreme Court. And then slipping in slightly lower in the judicial hierarchy, just in June, was a really interesting decision of the Court of Appeal about a do not attempt cardiopulmonary resuscitation at Addenbrooke's in Cambridge. So you'd think that out of that cluster of cases will come some interesting revelation about how we might move the law forward. And it's particularly interesting, I think, because in different ways this enables us to unpick what had become the constitutional settlement of regulation of medicine through the courts in a series of House of Lords decisions in the 1980s and one in the early 1990s. Cases which occurred about the time I started my academic career and shaped the whole way of thinking in early parts of my work. And they can best be summed up as a series of cases which argued that the key way of thinking about what doctors should do in the context of judicial intervention lay in this test from 1950s in the Bolam case. A case that held that the doctor is not guilty of negligence if, and I'm quoting as opposed to making a judgment about their gender, he has acted in accordance with a practice accepted as proper by a responsible body of professional opinion from the relevant specialty. And the perplexing thing about this decision is that despite being criticised, it seems to have held the judicial imagination and been used in relation to determining when it's appropriate to withhold treatment, when it's appropriate to remove the reproductive capabilities of women who can't consent for themselves, what it is that patients are entitled to know from their doctors. And I usually say to the students, if you know nothing else about healthcare law, you need to know this, and you can work out most of the rest from that with quite a high chance of accuracy. And I spent quite a lot of my work trying to understand why it was that approach held sway. And I argued essentially that the reason for that was the understanding we have of the nature of professional expertise. Well, tonight I want to talk about how we might think about the understanding that judges display of what it's like to be a patient, and suggest that we may be entering a new era in relation to that. So I want to go back to the Sidaway decision and note that in the Sidaway decision, what we see is the idea that patients are not like normal people, by which we mean barristers and judges. So in Sidaway, which was a case where the House of Lords had to decide what the obligations were of health professionals to volunteer information about risks, side effects, alternatives to patients. Attention was drawn by Lord Diplock to what a patient was not. We were not dealing, he said in the case before them, with a person who would want to be fully informed of any risks there might be, of which they are not already aware from their general knowledge as a highly educated man, that's a quote, of experience, so that they may form their own judgment as to whether to refuse the advised treatment or not. So that's not the sort of person that they had in mind when they were defining the obligations of doctors to disclose information. They were talking not about barristers seeking treatment from professional equal, but concerned with volunteering unsought information about the risks of proposed treatment failing to achieve the result sought, or failing to make the patient's physical or mental condition better. They went on immediately up that statement, Lord Diplock, to say the only effect that mention of risks can have on the patient's mind, if it has any at all, can be in the direction of deterring the patient from undergoing the treatment which, in the expert opinion of the doctor, it's in the patient's interests to undergo. So, not much good telling patients. The doctor cannot set out to educate the patient to his own standard of medical knowledge of all the relevant factors involved. He may take the view, certainly with some patients, that the very fact of this volunteering without being asked information of some remote risk involved in the treatment proposed, even though he describes it as remote, may lead to that risk assuming an undue significance in the patient's calculations. You can see here that there's an image emerging of what it's like to be a patient. We often talk in the legal literature about the importance of being able to assess information and make decisions on it. Lord Templeman said, the doctor is able, with his medical training, his knowledge of the patient's medical history and his objective position, to make a balanced judgment as to whether the operation should be performed or not. There's no guarantee that the patient is the same. They may not use the information wisely. A patient may also make an unbalanced judgment if he's provided with too much information and is made aware of possibilities which he's not capable of assessing because of his lack of medical training, his prejudices, or his personality. Thus, the provision of too much information may prejudice the attainment of the objective of restoring the patient's health. So we have a picture here of the patient as passive, ignorant, vulnerable to poor judgment, and if that's what you think patients are like, it makes considerable sense to see disclosure requirements as a component of a much more fundamental obligation to deploy professional skill in the interests of patients. And that seems to me to be the approach taken by the majority in Sidaway and goes some way to explaining it. It's also interesting that characterisation of patients as passive, ignorant and vulnerable to changing their mind and making poor judgments is pretty similar to the image that we've used about children to deny them autonomy rights. But it's also very much linked to the way in which people have thought about the sick role and the nature of being a patient. So sociologist Talcott Parson developed the idea that we need somehow to explain why, when we were sick, we were exempted from normal social responsibilities because somehow the things we couldn't do weren't our fault. They were because we were ill and not because of some moral culpability on our behalf. This let us off some things like going to work, but it brings with it some responsibilities, that we seek medical assistance and we cooperate in order to get well. So what you have is the patient and doctor bound together in a relationship that's constructed with very particular social expectations, with a very particular objective, that of making the patient well. Very similar to that articulated in the House of Lords in Sidaway. Talcott Parsons conceived the position of patients characterised by helplessness, technical incompetence, liable to a whole series of irrational and non-rational beliefs and practices, which clearly resonate with the judicial assumptions that I just cited. It would be wrong, though, to think that this is just another version of the debate about medical paternalism, because the relationship in this analysis between the sick role and the social value of autonomy is instructive. As one sociologist explains, in order to achieve the collective goal of re-establishing health, the patient has to accept violations of personal and bodily integrity, treatments that come with discomfort and sometimes even considerable pain. Disease is a threat to autonomy as it disables social contributions which legitimise individual freedoms. And of course it impacts directly on autonomy by way of incapacitation. The renunciation of individual autonomy in the sick role is only tolerable because it's relinquished solely in order to fully regain it. So we have a picture here that is not about denying the value of autonomy, but denying the value of autonomy while you are sick, and shows us that we need to think carefully about what it is that we think about people who are patients. Lord Templeman again from Sidaway. The objectives, sometimes conflicting, sometimes unattainable, of the doctor's services are the prolongation of life, the restoration of the patient to full physical and mental health, the alleviation of pain. The doctor, obedient to the high standards set by the medical profession, impliedly contracts, this was a negligence case, impliedly contracts to act at all times in the best interest of the patient. An obligation to give a patient all the information available to the doctor would often be inconsistent with the doctor's contractual obligation to have regard to the patient's best interests. The duty of the doctor in these circumstances, subject to his overriding duty to have regard to the best interests of the patient, is to provide the patient with information which will enable them to make a balanced judgment if they choose to make a balanced judgment. So we've not quite gone as far as requiring patients to accept treatment, and our law very, very rarely does this. But we've certainly picked up that conception of the patient as passive. So many of us have been anxious about that for a long time and arguing about where it should go. And it appeared that the courts were taking us away from that picture of the patient into promoting much stronger autonomy. So in the Pierce case, decided in 1988 by Lord Wolfe and used by Lord Wolfe in a lecture here in 2000 as, I think, possibly the only piece of real evidence in his speech that the courts had stopped being so deferential to doctors, was a reformulation of the requirement of disclosure following on from the decision of the House of Lords in Belitho. And in Pierce, he said, the test was that if there's a significant risk which would affect the judgment of the reasonable patient, then in the normal course it's the responsibility of a doctor to inform the patient of that significant risk. if the information is needed so that the patient can determine for him or herself, we've moved a little bit further to equality, as to what course he or she should adopt. And then we had a very tricky but well-known decision of the House of Lords in Chester and Ashfar, which discussed that dictum and also formulated in various different ways a duty to warn about small but unavoidable risks of serious adverse results. Similar formulation in which it was described by Lord Steyne as a prima facie right to know things in those circumstances. Other members of the House of Lords talking about a duty to advise as well as to warn. It cleared to be a clear commitment to increasing the exposure to liability of doctors in order to meet the rights which they said existed of patients to exercise autonomy. The Department of Health took it that way, and if you read the revision of the guidance that the Department of Health issued on consent coming out shortly after the Chester and Ashfar decision, you would think it was the only ever decision we had on informed consent, and that was all that you needed to know. But Chester is a very difficult case. It's a difficult case for tort lawyers because of the way it deals with questions of causation. But for my purpose today, the reason why it's difficult is it was a case in which it was conceded that there'd been a breach of the duty of disclosure. So there wasn't actually any need to define that duty precisely, which is why it wasn't defined precisely. You see in the subsequent case law a number of examples of judges expressing the view that it's right that we've moved in the direction of patient autonomy and enhanced disclosure rights. They tend to be the cases in which it doesn't matter very much because the breach is accepted or it's argued by those people defending the cases that actually they did disclose in the first place, and that's been rejected. If we take a decision which didn't happen since I've arrived here but did happen just down the road at University College London Hospital, Mr. Justice Cranson asking for some argument about the disclosure rules, even though he noted the defendants, as well as the claimant, advanced Lord Wolfe's formulation from Pearce as the current statement of the law. And they suggested that perhaps any discussion of those legal nuances may be regarded as unduly pedantic. I'm not sure why that's seen as a criticism. I can only plead for this judge, the matter is not as straightforward as it could be. And in Birch as well, the finding for the claimant that was made in circumstances where the defendant's expert witnesses gave evidence that the patient should have been informed of the information in question. So Mr. Justice Cranson didn't need to open up that question. He was still happy to find liability. But you need to recognise that it becomes quite difficult for defendants to deny liability in cases where they've already accepted that their practice fell below the standard they required of themselves. It's a little difficult then to come back and say, even if I didn't meet my self-imposed practice standards, it didn't really matter that I didn't meet them because my standards are so much higher than my peers that it should allow me to get away with the fact that at least I'm not as bad as they are. And actually it's very interesting that a significant number of the cases which seem to be interventions by the judges into the practice of doctors are cases where the defendant's evidence shows that they believed they'd done something that the judge found that they hadn't. So they put themselves in this position of trying to assert that it didn't matter, that they didn't do what they thought was best practice. So we have an indication the judges are thinking about moving, a degree of uncertainty about where they've moved to, and a degree of anxiety about whether or not that really is a clear statement of the law. And then we get this case from Scotland, Nadine Montgomery. This is a midwifery case, but in it the Pursuers' Counsel frankly summarised the issues as to whether or not the decision in Pearce, the quotation from Lord Wolfe that I've just given you, had effectively changed the law following the discussion in Sidaway. Well, the Council didn't go quite as far as to submit that in Pearce the Court of Appeal had approved and applied Lord Scarman's dissenting approach from Sidaway. He accepted that the test which it was sought to identify from the decision of the Court of Appeal in Pearce was pretty close to that dissenting view. Now, Lord Scarman had asserted a strong version of patients' rights in Sidaway, but still very much around the idea of being a patient. That right to know from Sidaway in Lord Scarman's account was still subject to something described as the therapeutic privilege. So still defined in the context of being in a patient's situation. So where do we think we might go in the reasoning from the Montgomery case? Well, the Inner Court of Sessions in Scotland, we don't know where the Supreme Court would take us yet, analysed the Pearce decision and said the test for liability for failure to warn set out in Pearce, if you read it as a whole, was essentially the Bolam test. That certainly matches the outcome in the Pearce decision, because in the question of how the case was disposed, the principal operative fact was the fact that there was a responsible body of opinion that would not have disclosed the risk. So although the formulation of the test seemed different, the application of it seemed straightforwardly the Bolam test. They went on to read Chester and Aschar, and there they felt they were unable to see any recognition in Pearce that the Court of Appeal had departed or advanced from Sidaway, or that what was said by the majority of their lordships in Sidaway required to be revised or revisited. Even when it came to discussing the well-known dictum of Lord Bridge in Sidaway, that it would all be different if people asked a specific question, the Court of Sessions indicated some concerns about the pursuer's suggestion that there was a duty to warn in cases of significant risk which arose by operation of law and was not to be measured against any yardstick of medical practice or opinion. On the facts, they decided that didn't call to be considered, as on the evidence there'd been no explicit request for information. And that's a very familiar pattern from the early post-Sidaway decisions, including an important one known as Blythe and Bloomsbury. So it seems, therefore, that Bolam's far from dead. By Bolam may be a little bit premature. And there are a number of reasons for thinking that that might be the case. The first come from discussions of the decision of the Supreme Court in Ainsbury and James. And here, Ainsbury is concerning a case of a hospital asking for permission in relation to a gravely ill man that it would be in his best interest to withhold certain life-sustaining treatments. And from the early stages of the judgment, when can it be in the best interest of a living patient to withhold from him the treatment which will keep him alive? On the other hand, Lady Hale said, when can it be in his best interest to inflict severely invasive treatment upon him which will bring him next to no positive benefit? Now, I think we need to recognise that Aintree is not an entirely easy case to make sense of. It seems to be a game of two halves. In the first part, which tries to explain what the legal principles are, Lady Hale makes very clear reference to the fundamental structure of the law and particularly of medical law. And on this analysis, she said, the role of the court under the Mental Capacity Act was not to decide what was in the best interest of the patient, but to determine whether or not to give or withhold treatment to the care that was being proposed by the doctors. And that placed the court in the position that the patient would have been in if the patient had competence, which is why I think it gives us some indication of the nature of the thinking. The court has no greater powers, she said, than the patient would have if he were of full capacity. And a patient cannot demand that the doctor administer a treatment which the doctor considers is adverse to the patient's clinical needs. The fundamental question is whether it's lawful to give the treatment, not whether it's lawful to withhold it. So it seems that the recognition of clinical freedom and the appreciation of the difficulties of clinical judgment doesn't seem so shaken as one might imagine from the analysis of the Inner Court of Sessions from Montgomery or the general approach that Lady Hale took in Aintree. Should acknowledge that she then goes on to address the best interest question directly, and so it may not be quite as clear as that suggests. But that's not, I think, what's of most interest to me tonight. Because what's most interest to me tonight is the changing nature of the people we're dealing with. It may be that this is a patient called Montgomery. My family would tell me that Montgomery women know their own mind. It may be that this is about a woman having a baby and therefore shouldn't be described in terms of being a patient at all, as my wife would frequently tell me. But this is a very interesting type of person and very different characterisation than I gave you from Sidaway. This is a woman having a baby who's a highly intelligent person. She had science degrees, she worked in a hospital, she had a mother who was a doctor and a sister who was a doctor. If she was not receiving answers in relation to matters which are of critical concern to her, the judge said, then in my judgment she wouldn't have accepted that situation and would have sought a second opinion or would have asked for a different consultant to be the treating physician. This is a case where the lady was short and had a reasonably large baby, although she said afterwards she felt it counted as larger than the doctor felt it was in terms of a discussion about the mode of delivery. There was a tragic outcome and she sued, and part of the question was, should she have been given the choice about a caesarean section? And she said that she'd expressed anxiety and she'd asked for information, but following an analysis of which this is part, it was clear that the judge didn't believe her and rejected the question. This was an asking questions type of case. But even more importantly, it seems on the basis of analysis to be a case in which it was reasonable to expect the patient to ask questions. And if she didn't ask questions, it was reasonable for the doctor to be worried about increasing her anxiety by putting things in her mind. So what we seem to have there is a different model of what it is to be a patient. A situation where if we take patients seriously and we don't infantilise them, we should recognise that it's up to them to make their choices. And if they're equal partners in the relationship with their health professionals, then with that comes the expectation that they'll assert their interests and explain what they need to know. And that actually means allowing patients to take some responsibility for their care, including not only taking decisions, but also living with the consequences. In the work that I do in terms of public service, this links a bit to thinking about public engagement. And the poverty of the old informed consent model is that it's based on the idea that one party knows a lot and the other person knows very little, and that therefore what informed consent is all around is about transferring knowledge from doctors' brains to, what's the phrase about lecturing, from the lecturer's brain to the student's note paper without passing through anything on the way. And that's a real problem if we're going to take seriously what it's like to be a citizen in modern life. And part of that is not just about the patronising nature of that picture of patients. It's also the fact that we get our information from many different sources. So another a bit of sociology from a study by Schilling, thinking about the impact of the easy accessibility of information via the internet, suggesting that this means that doctors may be used as the secondary rather than primary source of health advice. Individuals may consult them not as a consequence of assuming obligations contained in the sick role, becoming passive and looking for care and complying in order to get better, not as a consequence of those sort of obligations, but as a means of assisting their own health-related concerns. Positioning the doctor as an advisor in this way, however, revises the universal elements underpinning the doctor-patient relationship. So it isn't then a question of the doctor being the principal source of information and therefore responsible for making sure that I am well informed. The doctor is one of the sources of information and should be responsible for responding to requests and identifying some areas where it seems very clear that they don't think it's safe to withhold information. But if you're treating the other party to the relationship as an equal, you assume that they will take some active role in what they're looking for. Now, it's a little bit hard to see quite how that is going to work its way through into the new legal structure. But there are some clues in the decision of the Court of Appeal in the Tracy and Cambridge case, which raises a really interesting set of questions about how we capture the roles of doctors in this new sort of more equal relationship. Now, Janet Tracy was elderly and ill, and the case concerned a decision to write up a notice saying that it would be inappropriate to attempt cardiopulmonary resuscitation. Now, there are people in the room much better able to explain how that operates than I am, and I'm not sure I'd want it to happen to me. It's not like casualty where people walk away afterwards. It's a serious intervention and has risks as well as benefits. And the issue here was about whether or not it was necessary to discuss with Mrs. Tracy, and also secondarily necessary to discuss with her family whether or not doctors were thinking about whether to put one of these notices up. And rather like the complexities of the Chester and Ashar case, the doctors thought they'd done so. They thought they had discussed it with Mrs. Tracy, and they thought that she had indicated that she really didn't want to be involved in that decision in any detail and was comfortable for it. And on the facts of the case, which are only established over a 6-day hearing, it was found that there was a 3-day period while Mrs. Tracy was in hospital in between a first notice not to attempt cardiopulmonary resuscitation, which it was found to have been in breach of the duties of the doctors, and a second one put in place a little bit later when they had discussions where it was clear that she didn't want to be part of the discussion and that the family accepted that it was a decision based on appropriate factors. But in the course of this, and finding that in that 3-day period, the NHS Trust was in breach of its obligations, public law obligations. This is a judicial review action. They had some discussion about the nature of the legal responsibilities. And the Court of Appeal looked at the GMC guidance, which had already been before it in the Leslie Burke case, about whether or not these were a matter of clinical decisions, ordinarily governed by the Bolam framework that we've already had a look at, or whether these were of some different character. And right at the end of the judgments, Lord Justice Ryder characterised the way in which the GMC guidance described the situation as being one in which the patient is characterised as being primarily responsive. He said the duty to consult, which the Court of Appeal had created out of Article 8 of the European Convention on Human Rights, involves a discussion where practicable about the patient's wishes and feelings that's better undertaken at the earliest stages of the clinical relationship so that decisions can be reviewed as circumstances change. And this involves an acknowledgement that the duty to consult is integral to respect for the dignity of the patient. Now, what the Court of Appeal has done here is shift the focus away from the consent question, which is whether or not if something is done to me, I have given a sufficient legal authorisation by consenting, or the Aintree question, which is if I didn't have something done to me to which I'm not in position to consent, that I can have it done provided it's judged by the doctors to be in my best interests, or if the court is involved with a review, the court oversight. Out of the fact that in Article 8 of the European Convention on Human Rights, I have a right to respect for my private and family life, the Court of Appeal constructed an obligation that I should at least know that this question was being taken. So I have to be given an opportunity, and this is entirely consistent with what I've described in terms of the shift in the Montgomery case, an opportunity to find out whether I want to know more, to ask questions, and to probe the decision making. The Court of Appeal is absolutely clear that that gives me no right to have the treatment, but I have a right to know that that decision is being made. Now, this is a really interesting way forward. It respects the fact that we continue to allow clinicians to exercise their clinical judgment, and it leaves the consent structure largely untouched, but it pulls into play the fact that this can't be done except openly and transparency. But it also fills you with a certain amount of trepidation. Because if it's the case that it's part of the duties of doctors to make sure that people are having opportunity to get involved in decisions because they have to know they're happening and be consulted, it's far from clear how we could define or limit that approach. So in the case, they draw a distinction between the fact that this is a decision about not attempting cardiopulmonary resuscitation taken in advance and a decision that will be taken in the heat of the moment when you needed to immediately decide whether to intervene. And they said because it was an advanced decision, there was time to actually involve the patient and the family, and therefore it was disproportionate not to do so, given the engagement of the patient's rights to respect for her autonomy within Article 8 of the Convention. But if that's the case because there's time because in advance, it surely must also apply to the cases where there's time because you're in the position of discussing it with the patient as part of ordinary care. Secondly, although this is a case about a very specific and intrusive type of intervention, cardiopulmonary resuscitation, if this duty to tell me about things refers to everything that's left undone and not merely things that are contemplated to do, there's an awful lot of those things that people decide not to do in the course of exercising their clinical judgment. So how do we work out when this entitlement to be at least warned that someone is thinking about it and given the chance to participate, the duty to consult, is going to apply? And then what sort of aspects of my privacy really matter? Relatively easy in the Tracy case to identify this was a significant issue because it was an issue of a treatment that might have had the possibility of extending life. Although, as we know, when the family was involved the second time around, they too saw the argument that this was an inappropriate thing to do. So is it anything that affects my private and family life? Is it those bits of my private and family life that are also linked to other formulations, such as the right to life, the protection from inhumane and degrading situations, or indeed issues around reproduction? Really important possibilities there in relation to the law of abortion, onto which I shall come shortly. But what I think is more interesting in terms of moving healthcare law forward on this is that if we conceive of these issues as constructed under my right to private and family life, we also have the opportunity to ask questions about how they are outweighed. If the only question is the doctor-patient relationship, however we construct it, whether it's the passive patient or the new type of patient, we're only seeing part of the challenges. And this is familiar to clinicians and healthcare lawyers in lots of different ways. It includes the fact that the deployment of resource, whether it's your own time or whether it's equipment or whether it's public money, is deploying it in one place takes it away from somewhere else. So you have a question of how you balance the people who are not part of that relationship. The patient then is not the only citizen involved. It also enables us to think about where we balance my rights to privacy as a patient or as a citizen in the context of healthcare with respect for the rights and expertise of clinicians. And I want to come back to that a little bit later, but I want to get in there with a little bit of discussion, first of all, about abortion. Most of what I've described has been breaking open the idea that we can make sense of the two key players in the healthcare connection as being patient and doctor, or maybe not being patient or perhaps a health professional. But abortion law doesn't really feel very much like that. The Article 8 construction enables us to think a little bit about the way in which we might conceive other citizens' rights as being involved. But if you look at the activity around the courts in relation to abortion in recent years, it actually isn't very much about the doctor-patient relationship. If we go outside the courts, it's about the former Secretary of State for Health spending £1 million of the Care Quality Commission's money going in to find out that despite the fact that the organisations that were the cause, I should say, I was about to say the target, perhaps I should say the target of concern on this, had their paperwork reasonably in order, NHS trusts were not quite so rigorous about how they set up their forms. It might be about stings from the Telegraph. But even in the courts, you have the curate, Joanna Jepson, challenging the discretion of the Chief Constable of West Mercia for not prosecuting in what she felt was a potentially unlawful fetal abnormality abortion. You have issues around coverage in the broadcast media. You have challenges to confidentiality, where the Department of Health was forced to disclose information down to quite finely grained geographical areas about where late terminations happened, all part of a set of disputes into which the courts are drawn, which are really the marking out of big cultural battles in our society. And it happens on both sides. The BPAS attempt to persuade the Secretary of State to license the medical terminations outside of hospitals and clinics is a similar attempt to draw the court into this clashing of different values. So we need to be thinking about this not as just about the doctor-patient relationship, but as about a space in which many other things are going on. And the Supreme Court will have an opportunity to see whether that's its view of the question when it decides the Dugan case, due to be argued in a couple of weeks' time. In that case, two midwives who'd been working in the same hospital for many years sought to get their employers to relieve them from their responsibilities of managing labour ward because they said managing labour ward came within the scope of their rights under Section 4 of the Abortion Act to refuse to be engaged in any termination processes. And their claim was that this covered the entitlement to refuse to delegate, supervise and or support staff in the participation in and provision of care to patients undergoing termination of pregnancy or feticide through the termination pregnancy process. Now their duties, it was agreed, were essentially around the management of resources within labour ward, taking telephone calls from the fetal medicine unit to arrange medical terminations of pregnancy, doing handovers on every patient, which might include patients who had had terminations, allocating staff to patients on the ward or who were admitted, accompanying obstetricians, acting as a point of contact, a whole series of things which might bring them into contact with those women who had used abortion services. Now we need to decide whether or not this is merely a clash of morality or whether or not there's some set of balancing that needs to be done. Two things I think just need to be said at this stage in the evening. One is that this is another opportunity to unpick a settlement from the 1980s. The Janaway decision of the House of Lords came up with a version of the scope of Section 4, which is now under scrutiny. So another example of our chance for the Supreme Court to set a new tone. The second is that it's possible to tell two stories about the position that these women found themselves in, because the way in which terminations were organised in Greater Glasgow had changed quite significantly while they'd been working on that ward. So at one stage, the only terminations that were going onto that ward were late terminations for fetal abnormality, and if at the period there were only 175 such terminations across Scotland. So you were moving from a situation where it was probably quite unlikely that they had frequent contact with women in this position. They reorganised the services so that all terminations were run through the labour ward in question. And by 2013, there were 2,943 terminations in the Greater Glasgow and Clyde area, not all in the hospital where they worked. But there is a reasonable story about the change of scale of the challenge that's there. But there's also a feeling that somehow the law is being pulled in, as it's been in relation to the end-of-life care cases, to being the place in which we're trying to make sense of serious clashes in our society. And if we just look, as an illustration of that, to the proliferation of interveners in this case, and with colleagues from Southampton, Hazel and Caroline, we've been doing work on trying to understand the intervention process and what it does to lawmaking. And these are just the interveners in the cases that I've been talking about over the past few minutes. So in cases which start about being individual rights of clinicians or individual positions of patients, we find ourselves drawn in to a lot of controversy of different views on what the right solutions are. So it seems that to think about this as a subject which is concerned just with the rights of patients is really rather misleading. There's also some very interesting activity going on mainland Europe, exploring the extent to which Article 8 rights, that's the right to respect for our private and family life, require the state to make good on its promises. So 2 cases from Poland essentially concerned with if the legal system permits terminations of pregnancy, then it has to make that a practical reality for women. 2 cases involving end-of-life care from Switzerland, in which the European Court of Human Rights has explored the extent to which if you permit assisted dying in a jurisdiction, that then commits you to extending the way you should permit it to ways that are non-discriminatory and restricting the thresholds and barriers, such as having to get prescription-only drugs, that enable you to exercise those liberties. These are 2 cases which were discussed in the Supreme Court in Nichtinson, and clearly part of the picture of where we may be going if we take this step, that this is principally about our Article 8 rights. The Costa and Paven case from Italy is another one of delivering on your promises. If we allow pre-implantation genetic diagnosis for some conditions, and we have a parameter for permitting terminations of pregnancy for fetal abnormality, which is not matching when PGD is available, then that becomes an element of inconsistency. And the Girisotto case is one that's been declared admissible, but a really interesting one for someone who's been an NHS commissioner, was one as whether you had a human right under Article 8 to have treatment that the NHS didn't even think worked. And if you want to think of a local example of that, the Asher King case from a few weeks ago would be very much in that sort of territory. So it seems that if we take ourselves down this human rights route, there are a lot of really interesting and tricky questions. Whatever they are, though, they're not really questions about being a passive patient. They're questions about being a legally equipped citizen. So as we reflect on these key cases which have fought out big moral battles and sought to put them into legal paradigms, this is the summary of where I think we find ourselves at this stage. It seems to me that we are at a potential watershed. We have this series of recent and forthcoming Supreme Court decisions which provide a significant opportunity to revisit the foundational principles of medical law, those ones that were established by the House of Lords when I started my academic work in the 1980s. Now, those decisions set out a particular position about judicial oversight of clinical judgment, and that position remained remarkably stable over the following 3 decades, despite consistent challenge by commentators, many in this room. And it was based on the ascendancy of the Bolam test as the golden thread running through the law. And it was based, secondly, on an image of patients that stress their ignorance and vulnerability. Now, this new cluster of cases gives an opportunity to revisit the law dealing with decisions at the end of life for incapacitated patients, revisiting the Bland decision, that's Aintree. It gives a chance to revisit the position of patients at the end of their lives with capacity, the Court of Appeal in Tracy. We have the Supreme Court's reflections on the position of non-patients at the end of life in Nichtinson, and there's a strong argument made by people in this room about redefining that area as end-of-life law as opposed to medical law, because there was no suggestion that in Nichtinson this turned on the fact that they were patients. We know those already. We shall shortly know where this takes us in terms of disclosure obligations. Will the Montgomery judgment displace Sidaway, or will it return to the Sidaway settlement? I very much hope that the Dugan decision will shed light on how we might balance the rights of professionals and service users, although given that it's not even argued, that has to be pretty speculative. That's a remarkably important constellation of decisions and probably collectively serves to reshape the questions that healthcare lawyers will need to explore in this new context. It needs to be a genuine re-examination, though, not a return to our criticisms of the old Bolam settlement. I've suggested that what might be emerging is a change moving from the way in which people using health services are conceived no longer as patients, but as citizens. And I think that brings at least two shifts of emphasis to the structure of our law. The first is that we should no longer understand patients as being in some form of sick role, merely passive recipients of altruistic care given by professionals in the patient's best interests, and therefore expected to comply with this project of getting well again. Instead, we're to be citizens with legally recognised human rights that we don't lose when we go into health services, and with lives that go beyond our interactions with health professionals. Now, I've tried to hint that I don't think that necessarily needs to lead us to the stage where the health professionals have greater obligations. First of all, because our respects for our right to family and private life, including autonomy, means that we have to be allowed to make choices. As the Montgomery case shows, women using maternity services are quite capable of taking responsibility for their own care. We shouldn't infantilise them or patients in general by thinking that they'll only know things if professionals tell them the disclosure requirements are considered away, and they'll only understand things if professionals explain them. Taking patients as citizens more seriously means recognising that disclosure requirements in tort law are not the main way in which informed decision-making should be supported. Indeed, informed consent, despite its popularity in the bioethic literature, seems to me to be a flawed concept too closely linked to the passive role of the patient. It assumes that decisions people make when using healthcare are focused on whether or not to accept treatment offered to them. But real people place those decisions in their broader lives and seek them from many sources. In the new paradigm, as patient as citizen, it's for them to choose when and how to seek information. As the Tracy decision explores, we might expect to see some legal protections to their right to know decisions are being made so they can decide how they wish to be involved. And that right's independent of the issue of consent, not least because it relates to decisions not to offer treatment when consent never comes into play. And building on autonomy as an Article 8 right may loosen the shackles of the forms of action problem we've had about is it trespass or is it negligence, or if you're Lord Templeman, in Sidaway, is it even contract? And opens up a potentially interesting paradigm for analysis. So maybe we're now talking not about informed consent, but the duty to consult. And while I've argued that those recent decisions show a fundamental shift in the judicial conception of the patient with wide-ranging implications, I've not suggested that the judicial conception of the health professional has undergone a similar transformation, because at the moment I don't believe that's the case. Lady Hale's analysis in Aintree firmly reasserted the principle that decisions on whether it was appropriate to offer treatment were a matter of a clinical judgment, and all that the court could do was step into the shoes of the patient and decide whether to give or withhold consent. The Court of Appeal in Tracy may seem to promote a more interventionist position, but it's expressly not about the substantive decision on whether or not to attempt cardiopulmonary resuscitation. Indeed, the Master of Rolls stated that an interpretation of Article 8, which would even include the right to a second opinion, would represent an unacceptable intrusion into the realm of clinical judgment. Nicklinson barely touches on issues of health professional involvement, but where it does in Lord Neuberger and Sumption's summaries, the summaries of the relevant principles are thoroughly orthodox. There seems to be nothing yet in this cluster of cases to me to displace the ascendancy of Bolam as the measure of professional judgment. But this shift of emphasis also includes a recognition that we're dealing with citizens' rights under the European Convention that may have far-reaching consequences for the structure of healthcare law. This is about the extent to which the human rights claim give rise to positive entitlements, and also to a slightly lesser degree the balancing of those rights with other legitimate concerns and exploring the rights and freedoms of others, at very least the health professionals, as we'll see in the Dugan case. Now, those are rights that aren't based on being a patient under the care of a doctor or any other health professional, but on a citizen seeking to secure the conditions that enable people to live the lives they want to live. The Tracy case imposes obligations to be transparent about the fact decisions are being made about a patient's private life. So my suggestion then is the new dawn for healthcare law lies not in the abandonment of the Bolam test, as I think we've grappled with for 30 years, but in the rediscovery of the idea of rights, and in particular the reformulation of issues about positive rights under Article 8. Decisions of the European Court of Human Rights on the requirement to make access to service a practical reality, not merely a legally permitted aspiration, and to be consistent in restrictions imposed on available positions may open a Pandora's box. Many of these issues become issues about the enforcement of morality and bioethics, and many of them are sat within the margin of appreciation. You could say recent European court cases suggest a move towards narrowing that margin by requiring states to be consistent in the restrictions that they impose, to articulate the justifications of those restrictions in terms compatible with Article 8, and to show evidence that those restrictions are proportionate. And that takes us very briefly to Nicholson. Because closer to home, the question of who settles that margin of appreciation has become of fundamental importance. As Nicholson sets out so clearly, human rights are centrally within the jurisdiction of the courts. The Supreme Court has thrown down the gauntlet to the legislature on the specific issue of assisted dying, and maybe a mini constitutional crisis around that ahead. But if I'm right in the thinking about the impact of human rights, that's only the start. The next stage will be developing healthcare law through the spelling out of the scope of our rights as citizens, not just as patients awaiting the administrations of professionals. I've suggested this will leave judicial protection of clinical freedom intact, but it will bring out into the open and place in the context of the obligation of health services really significant challenges about giving people worthwhile choices. Now, the eagle-eyed and well-informed of you will have spotted in my headings things taken from the poem W.D. Yeats' The Second Coming. I've suggested that the old idea of the patient at the centre of things has fallen apart, can no longer hold anymore. I've worried about the extent to which the extension of Article 8 looses some anarchy on the world, but also suggested it's probably here already if you look at the litigation around abortion of end-of-life care. I reflected on the idea that Sidaway might look rather innocent now. And I opened up with this little cluster of opportunities for the Supreme Court to dispense its wisdom with expecting some revelation at hand. So hopefully there's a second coming. But as Yeats indicated, we're not quite sure what it's going to look like, and possibly the rough beast slouching towards Bethlehem won't be as attractive as we might hope. Thank you very much.
Well, Jonathan, thank you for what I promised would be a truly fascinating lecture. I'm sure you'll all be more than fulfilled that expectation. We're not going to have questions and answers, although I might stop you bearding Jonathan a little bit later over drinks. But I would like to say that it has certainly prompted in my mind a series of questions which I don't find at all easy. Perhaps I can just throw out a few, not in order to ask Jonathan to answer them, but for you to kick around and no doubt formulate your own questions. And in putting these, I hasten to add that I am being deliberately provocative. If you were to infer from my putting the question that I've got a particular view as to the answer, you'd be very probably wrong, because first, I really don't know the answers to most of them. In Sidaway, it seems to me that Lord Scarman and the other lords had different views on the question what a patient might reasonably expect to be told. The answer given by the majority might be thought today to be outdated and over-paternalistic. Does that make the question itself, i.e. what the patient would reasonably expect by way of disclosure, involvement in decision-making and so on, an inappropriate question, whether one's looking at it under the law of tort or under the Human Rights Act? But if it remains an appropriate question, who is to determine it and how? If we move away from attaching a high value to the doctor's views on what is in the best interest of the patient, and look at it in a more open-textured human rights way, then really, how is the court to decide the question 8 balance? What are the qualifications and experiences of judges in what may be a highly complex area that enables them to answer that question any better than the doctor? What evidence is there about what patients in fact expect? Is there any empirical research? Does the judge just decide it on their own intuition and where they happen to be on the moral spectrum, valuing autonomy against some other right? Because, as Jonathan has indicated, lurking underneath the question posed are very often some moral dilemmas on which different views may be held. What is the star by which the judge is to be guided? Indeed, should we be concerned with what the hypothetical average patient might reasonably expect, or are we concerned with a particular individual? In the financial world, the Financial Services Authority now requires financial advisors to take clients through an unbelievably long and tedious list of questions, including a large number of hypotheticals about the risks which the investor is prepared to bear and how much he trusts it to the financial advisor. Are we heading towards a world where doctors will have a similarly long list to go through with patients saying, would you like to be informed about a risk attendant on a particular treatment or not having it, if that risk, in my professional opinion, exceeds 1 in 100, 1 in 500, 1 in 1,000, then according to the tick box exercise, then in a sense you would have had the degree of risk aversion of the individual patient. Somehow that strikes one as really a rather unrealistic scenario in a busy A&E environment. But if we haven't got an empirical basis, how are these real questions to be answered? If you move away from what has been the approach to say, well, the court attach very high value to what the doctor believes genuinely to be in the best interest of the patient. And then, in addition to questions about the determining the reasonable expectation of the patient in matters of disclosure, consultation, shared decision-making and so on, what may society reasonably expect of the patient or the individual, the customer, the client, the human being, called John Smith, whatever you like? And again, Jonathan has opened up some very interesting questions about that. Is there here a clash of moralities? John Smith is a healthy young man. The state happens to have invested a lot in education. He's a married man with young child dependents. He drives a car. We require him to wear a seatbelt for his own protection. We may say that we have a proper societal interest in doing so. If he suffers a serious injury, he may take up hospital resources, which could have been avoided if only he had the unselfishness of wearing a seatbelt, and he may be unable to fulfill his family responsibilities. Supposing that a serious accident happens, whether or not he's wearing a seatbelt, he requires a blood transfusion. If he has it, he will make a full recovery. If not, he may die, and the state will then have to support his family, or he may, by refusing, have to have long-standing medical care, occupying bed, and great expense. He refuses to consent. What responsibility does he owe to his family and to the state? How do we balance that against his autonomy? Well, there we are. We could go on and on and on and on. All I want to say is thank you for a fascinating inaugural. It seems to me it throws open a huge number of questions. Congratulations and best wishes on your appointment.
Can I just add my congratulations? It was a fantastic lecture. We had a real treat this evening. a lecture that was a model of clarity, that had such great intrinsic interest. Thank you very much indeed for that. Raised a lot of very important questions, and also the treat of having Lord Toulson here to raise some additional questions and give us a sense of the kinds of issues that the judges have to grapple with all the time. So thank you very much indeed. All that stands between us now and a drink is for me to formally inaugurate you as a professor. So, Professor Jonathan Montgomery, it gives me great pleasure to inaugurate you as Professor of Healthcare Law in the Faculty of Laws at University College London, and in the long tradition of the faculty, which stretches back as far as 3 years, I always felt I ought to have a sword or something in all the lectures, and I couldn't get a sword. So what we have is the inaugural pen, fountain pen, and in this box, I hope there is a pen, I think there is. There is yes there is, look it's there. You can show the audience. And there's a little note that says presented, imaginatively, it says presented to Professor Jonathan Montgomery at his inauguration as UCL Professor of Healthcare Law on 30th of October 2014. So there you are. Thank you very much. Upstairs now, have a drink, and ask Jonathan and Lord Toulson some very difficult questions.